Welcome to Short Legal Briefs with Josh Long, where experts in the natural products industry explore the intersection of business, law, and regulations. Tune in for the next 15 minutes to learn about policies and controversies affecting dietary supplement, food, and beverage brands.
Welcome to Short Legal Briefs. I'm Josh Long. In the last program, I interviewed two attorneys who support FDA's proposal for a mandatory dietary supplement product listing. In this episode, we explore criticisms of FDA's proposal. Joining me to discuss the issues, Aaron Sechrist, an Executive Vice President with Now Health Group, Mitch Coven, founder and CEO of Vitality Works, and Stephen Shapiro of counsel to the law firm Rivkin Radler. Gentlemen, welcome to the show. Thanks for joining. We're going to start the lightning round with you, Mitch. In 60 seconds, what are your chief concerns with FDA's proposal?
Well, I think there's been a misunderstanding about the industry and consumer impact for this potential change in mandatory product listing. First of all, it's been said that there are approximately 50 to 80,000 labels out there in the US marketplace. Kara Welch has mentioned that, as well as some other industry folks. Currently, the ODS under the dietary supplement label database already has 79,000 labels listed. And that doesn't include Vitality Works, my company. We have over 30 to 40,000 labels in the US marketplace as a single source company. So the impact is much greater. There are many more labels. And the cost for implementation, there have been discussions about potential user fees for mandatory product listing that have ranged as high as $500 per listing. It may be free, it may be $5, but the economic impact is much greater than has been expressed. That's going to really hurt mom and pop health food stores, especially, which I can circle and talk more about a little bit later.
Thank you very much, Mitch. Aaron, David Spangler of CHIPA recently mentioned to me that a product listing would provide more visibility into the marketplace, allowing FDA to do, quote, smarter enforcement. And Sidley Austin Scott Bass said large brick and mortar and online retailers are not going to sell products unless they're listed under this regime that we're talking about. Do those ideas resonate with you? And if not, why not?
I would say no. I think you have to start with the assumption that there's a gap. I don't think there is a gap in terms of regulation. I think there's a gap with enforcement. If you look at all the regulations that we currently have, we have the Dietary Supplement and Non-Prescription Drug Consumer Protection Act of 2009. It already requires domestic address, domestic phone number on the labels. You've got FSMA that requires biennial registration of food facilities. You've got DSHEA that already requires any new dietary ingredients to be to notify the FDA within 75 days before introducing it into interstate commerce. You've got AER, SAER legislation requires notification to the FDA of serious adverse events. I think you've got lots of regulation on the books. The FDA just needs to enforce.
Thank you, Aaron. Stephen, some critics of a mandatory listing have argued that the so-called bad players will simply ignore the requirement like they do with other provisions of the Food, Drug, and Cosmetic Act. However, FDA has a solution. Specify that failure to list is a prohibited act or a violation of law. Wouldn't that provision help FDA hold the bad actors accountable? And if not, why not?
Okay, no, look, I don't think so at all. First of all, what I want to say is there's already a provision on the books that requires companies making claims with labels with structure function claims to submit a 30-day letter. All right, FDA even gives them a cursory review, issues a courtesy letter. FDA does absolutely nothing with this database. It's a tremendous database. All right, that's number one. Certainly retailers can ask companies, hey, can we see your 30-day letter? Can we see your courtesy letter? That provides a lot of information. Look, and as for this mandatory enforcement or whatever it is, they're talking about fining companies, some kind of fine. All right, and I don't really see that. What is that supposed to do? If you're selling a company a product with an illegal ingredient, is the concept of you may be fined, is that the big deal? All right, just as an analogy, I was driving on the interstate this weekend, 10 miles over the speed limit, certainly risking a fine, and cars were whizzing by me. All right, if you're selling an illegal product or you're selling a product with an ingredient that FDA objects to, so what? You'll be fined. I mean, why would you submit the label, and what would FDA do with it if they're not going to be revealing it?
Thank you, Stephen. Mitch, you alluded to this earlier. Some people have suggested requiring firms to list their products with FDA would not be a heavy lift. It would not be burdensome. For example, I presume that product labels are at your fingertips already. I'd like you to address the burden question.
Sure, we're a private label company, so we produce products that may be at the local co-op or mom and pop health food store and small chains all across the country. The fees associated with it, we'd have to pass back to those stores, and at a minimum, we see that being anywhere from $6,000 a year and up that we'd have to pass through to those mom and pop stores. They're already struggling to compete with the very large chains and the big .coms. So they're looking ways to individuate with their own branding of products to give consumers a reason to come back into their store. Additionally, the staffing that we would have to bring on to manage the upload of the labels, and then the change control every time there's a minor change on the label and posting that back up to the site, we think is going to be a notable six-figure fees and just additional staffing that would increase the price points that we have to charge back to to the stores and buy our product. So it's a big lift. It's a big concern. I've been doing this 39 years. It's one of the biggest concerns of any proposed regulatory change I've seen in all my years.
Thank you, Mitch. Aaron, FDA thus far has not shared its specific legislative proposal on mandatory listing. We just understand the broad strokes. With that said, can you envision a scenario in which you would support a mandatory listing? For example, a quid pro quo as part of DSHEA 2.0 reform?
I don't see a scenario where I support this. Again, I have an issue with the FDA enforcing all of the regulations that are on the books. You know, Stephen talked about there's already a requirement for facilities to register under both the Bioterrorism Act and FSMA. And you have companies that don't do it. And the FDA, if they really wanted to crack down, why not start there? I mean, if a company's not even registered, they're clearly not doing the other things that are required of dietary supplement manufacturers. So I think there's already ample ways and opportunities and means for the FDA to take care of this problem. It's about enforcement. And as soon as, once they enforce things, if we determine there's still an issue after that, then let's talk about what that may look like. I still don't think that this is the answer, but let's start with enforcing laws and then see where we go from there.
Thank you. Stephen, are you concerned that FDA or third parties like private plaintiffs or state attorney general would misuse or exploit this FDA dietary supplement product database, and that would be harmful to legitimate or the good players in the industry that are following the rules?
I'm not really certain how, these third-party players could use the database. The labels are already out there, all right? They can find it. I mean, that's really, look, the third-party plaintiffs and all of that is always a concern. I don't know if that's my biggest concern here, all right? I mean, look, part of this, I was just thinking about this morning when I heard I was going to be doing this, all right? What really is the purpose of this, all right? Why are we submitting the labels? What are consumers going to say? All right, are we going to advertise? Is this going to be a big deal that all the labels are submitted to FDA? I mean, we do realize that the labels say right on them that these statements have not been evaluated by the FDA. So to me, that's just consumer confusion. I don't really understand, this need for a database. All right. I mean, look, one thing that I would prefer that we've been asking about for a long time is greater enforcement on NDIs. All right. For example, we have asked many in the industry that there be a import alert on NDIs, and FDA sent a letter basically saying, well, if we don't know that they're violative, we don't know that they're actually NDIs, how can we can't enforce? And that's, just give me another minute, sorry, that's absolutely untrue. All right, they can issue an import alert based on the fact that these products appear to be new dietary ingredients, and then the companies would have to submit proof of marketing or proof of GRAS before they could come in. I mean, that's a big enforcement step right there. That really is not a lift, just issuing an import alert, and they haven't done it.
Okay, thank you. Thanks for answering the questions, gentlemen. Mitch, I want to give you 90 seconds to make your final case and explain to the audience why you are opposed to FDA's proposal.
Yeah, first of all, I'm not sure what the problem is. If you look at all the consumable products that are out in the US marketplace, I would argue dietary supplements are the safest compared to drugs and foods. If this is a safety issue, why isn't there mandatory product labeling for peanut butter and spinach and ice cream? Those are products are, and meat. There are more issues there than there are with dietary supplements. So it's a much ado about nothing. Those of us in the marketplace that actually do the manufacturing for many of the brands, I'd argue that 50 to 80% of the products in the US marketplace are coming from a couple handfuls of manufacturers. We're inspected by the FDA every other year for a week. We don't have any corrective actions. They know of us. We're doing a good job. This proposal for mandatory product listing is going to penalize the good players and not accomplish the mission in trying to increase safety, increase label accuracy, as has been mentioned, of the players who are already not disclosing what's in their product. They're not going to post the labels, and as they do, what's really in the product that's being adulterated will not be posted on that label. And I don't believe there's a benefit to consumers where they can go in and see that there's 300 options on buying valerian. They want to go into a store. They want to interact with a knowledgeable person in the aisle. The buyers in the stores want to work with their sales broker. They want to train her with a company. They know enough to never just trust a label. They're going to really want to know about that company and vet those products, and that already exists. So I don't see mandatory product listing accomplishing any of the missions that we're all concerned about in increasing consumer safety and accuracy in product labeling.
Thank you very, very much. Aaron, what are your final thoughts?
Yeah, I would say, I would echo, some of the things that Mitch said. Certainly, there are a myriad of laws already on the books. The FDA simply needs to enforce. They have a lot of tools in their toolbox. They've got mandatory recall authority. They've got administrative detentions. They can suspend food registration for facilities. They've got import refusals. They've got injunctions, seizures, all of those things at their disposal. They simply need to use it. The NIH database has over 125,000 labels in it, and it's searchable by ingredient. So again, I feel like this is the FDA calling for something that is already available. They don't need this. All of the tools are at their disposal. They simply need to enforce the laws that are on the books.
Thanks, Aaron. Stephen, you get the last word.
Okay, thank you. Look, first of all, I want to echo what Aaron and Mitch said. Obviously, I'm a lawyer, so I'm not involved with the cost as much. But look, first of all, you've got the 30-day letters that I mentioned previously. All right. FDA has never enforced that provision, and I think it's a good provision. All right. FDA has never, issues courtesy letters, and even though those aren't definitive, FDA doesn't even follow up on them. All right. Issue a courtesy letter, follow up in 6 months and see if the change has been made. None of that is really, they haven't exhausted that. They haven't said, we've taken that provision that's been on the book since 1994 and we've run with it as far as we can. That's number one. Number two, the idea that this is going to flush out the bad actors, that FDA can fine them, so they're automatically going to what? Disappear or register their products? All right. I mean, if you're selling a product, that FDA objects to, and I'm not taking a position on CBD one way or the other, but that FDA has stated that CBD has an issue. Do you register that label or you don't? How do you make that decision? Is this going to force companies to take products and register them? I kind of doubt it. All right. And then the last thing is, what is FDA going to do with this information? All right. Is this going to be like a pre-approval process? Are they going to review the labels? It seems that they're just going to be thrown into a database like the 30-day letters, and what's going to happen with it. All right. These databases exist. This is just for the reasons really that Mitch talked about, something that's going to be a big cost for legitimate companies, but I think is going to have absolutely no effect on the so-called illegitimate companies. What are they going to do? If they're caught, pay the fine and then just continue on their merry way. To really do any enforcement beyond the fine, FDA is still going to have to issue a warning letter or take real enforcement action.
Thank you very much. I want to thank our guests, Aaron Seacrest, Mitch Colvin, and Stephen Shapiro. I'm Josh Long, and we'll see you in 2 weeks for another episode of Short Legal Briefs.